Okay, this next session of the forum is going to be questions from the audience. I'll select people at random. And again, I would advise you to try to be respectful in your questions. Try to be as courteous as you can. I'm sure that some people might want to test or challenge one of the candidates, and that's fine as long as it's done with respect and civility. Also, let's try not to make campaign statements. If you have a supporter up here, or you are a supporter for one of the judge candidates, that's fine, but this is specifically about questions. So if I don't hear a question from you, I'm going to ask you what that is in the interim of listening to whatever you may want to say. So again, let's a show of hands. I see one over here right off the bat. You can start now. So this is a question limited to 1 minute. And each candidate will then have 2 minutes to address it. Again, there will be time. So 1 minute to ask your question.
Okay, this is for Mr. Hermanson. Okay, you made a comment to my mother when she was in court supporting my niece. My niece had a traumatic childhood in which, observed by her best friend being shot by a murderer, was murdered at the age of 5 in her school. Your office ignored my mother's letters and my niece and her mental capacity due to her tragic past. Okay, you had the nerve to point to my niece in the court and say, if you ever see my niece back in court, I will make sure you will never get out of prison again. It says, then you threw me a box of tissue.
Okay, what's your question then?
Okay.
You're making a statement. Ask the question.
I said, this is my question right here. Okay, you didn't find one of those programs that you just talked about with the community. You said you were going to find, programs to help out the community. Well, you never helped her out. You just put her in prison.
Okay, that's
and
1
it
minute.
says you keep talking about my niece. You had no compassion.
Okay, let's let him answer the question.
I'm very aware of your case. And to say I have no compassion for a child who had a mental health issue is absurd. I spent a good portion of my career dealing with individuals with developmental disabilities and mental health issues. And in your niece's particular case, I could have sent her to prison the first time, and I gave her an opportunity.
But you never said
Wait, it's not a debate now. You have to let him answer the question.
She engaged in conduct a second time that warranted prison. I never said she would go to prison forever. I could never say that. But I will look at somebody and tell them, if I'm giving you a break, and you come back in here, I will not next time mitigate it. I was being honest. And she came back, and I held my word. That at that point, I was going to send her to prison for what she did the second time.
Okay, thank you. Next question. Yes, ma'am.
Okay, this is for Mr. Hermanson also. At a recent forum, you defended a statement that you've since removed from your website. It defines a prosecution attorney as having the obligation to convict the guilty by providing true facts and telling the truth, and the defense attorney has no obligation to ascertain or present the truth even if he knows it, in other words, lie. You defend the statement by stating it was a quote from the United States Supreme Court Justice White. However, it's obvious that you believe it. You posted it on your website. Defended the statement at a forum, and your friend Jeff Oliver submitted the same information to the Ledger-Dispatch in a recent letter to the editor.
Okay, get to your question.
Okay. My question is, if you have this opinion about defense attorneys and their clients, how can you be a fair and impartial to the defense in any case that comes before you?
Ma'am, I quoted the U.S. Supreme Court in defining what the roles of individuals were in the court. And I will stand by my position that the most important quality of a judge is being able to understand the law and understand what the roles are. If you don't have a basic understanding of what individuals' roles are, how can you be effective? Doesn't mean you're biased. It means you understand the law. And yes, the U.S. Supreme Court said that the prosecutor is held to a higher standard. Now, at the same forum, my opponent called me a racist, correct? He told me that I lied, told me that I didn't seek the truth, told me that I moved here to be a judge, instead of other things. That is the action of a defense attorney, not of a judge. A judge is to seek the truth. a defense attorney does not have an obligation to seek the truth.
Mr. Hurwitson, you say that the prosecutors are held to a higher standard, yet you yourself, in case, by the way, as you know, I'm a private investigator, and as a matter of public disclosure, I do some work for Jeff, but I'm an independent, and I work for other attorneys as well. Mr. Hurwitson, it's been my experience that you sometimes ignore the rules of court and evidentiary proceedings, or seem to, in that you fail to respond to attorneys' motions and requests for information required to be divulged under court's discovery rules. In several cases that I've been involved in, have allowed. I'll get to the question.
You've got 10 seconds to ask.
I'll get to it. You don't seem to have the ability to be as fair and impartial and held to a high standard.
So you're making a statement. You have to ask the question.
As you say you are. However, I'd like to know the question. I'd like to know how you will be affected if you are elected as a judge in your review of cases, and when you leave a lot of things out, like you do as a prosecutor.
Very little word.
I take exception that I leave things out as a prosecutor. I appreciate that you work for a defense attorney, and I appreciate sometimes defense attorneys request things. That does not mean that they're entitled to them in the time frame that they request them, nor in the process that they have. There's a specific process for discovery. I've never been sanctioned by a court. I've never been reprimanded by a court. Nor has it ever been brought to a court's attention. I have intentionally, nor negligently, tried to hide or not provide any evidence. So that implication, sir, is false. And I'm only aware of one case that you've worked with me on. One case. And it's still going.
This is not a debate. Not a debate. Next question, please. Yes, ma'am.
Both of you, in your opening statements, you spoke of the American Legion. Mr. Seaton, you did speak of some time in the service. I'd like you to both tell me what the amount of time you have given to our country, each of you.
Whichever one wants to go first, that's fine.
At 15 years old, I got paralyzed. And I had to learn to walk again. I had to learn to do a lot of things again. Character is built through many avenues. 2 times I tried to go into the military, into JAG. You know what I learned? The government discriminates. They don't want people that are paralyzed in the military. That doesn't mean you don't serve your country. Every day I try to keep this community safe. Every day I teach my children about the Constitution and the ideology that makes our country great is supporting our country. I raced for our country. I got to wear the colors of our country when I raced a bicycle in Europe and around the U.S., and that made me very proud. It's a wonderful thing. But to say that individuals who can't serve in the military can't serve the country does a disservice to a lot of individuals out there who are unable to serve.
Mr. Seaton gets a chance to respond to that as well.
Okay, I told you I'm retired from the military. I enlisted in 1973 and I retired in 1999. I was in the military the entire time. But that's not where the service to my country stopped. I took an oath to support and defend the Constitution of the United States when I became an attorney. And that is codified in Business and Professional Code 6068. And the second portion of the 6068 statute states that every attorney shall seek the truth. And ladies and gentlemen, I seek the truth. Thank you.
Question, Ben. And this is for both candidates. What attribute or quality do you feel you possess that sets you apart as a candidate and will make you a better judge for Amador County?
I don't know that there's one specific attribute because there are so many that are important. Integrity, honesty, objectivity, that, in my mind, is the essence of what every judge should be. How can a person's integrity be developed? It's developed on a daily basis. How can his or her character be developed? Again, on a daily basis. I've been in this community for 20 years, but I was someone else before I moved up here and became a lawyer. My experience in the military and as a deputy sheriff, as well as an attorney, has enabled me to, I believe, deal with people, humans, one-on-one. Understand where they're, I'm going to use the term, where they're coming from, what their mental state is, not being a psychologist, but why are they saying what they're saying? And in my opinion, there's no substitute for experience. My bachelor's degree was in social work. As I told you earlier, I was a social work psychology specialist years ago. But for the past 36 years, I've been within the legal system, both, again, law enforcement, military, and as a private attorney, and most of that is as a defense attorney. So I think the ability to accept individuals when they walk in the courtroom on an equal basis, regardless of who they are, what they are, what religion they are, what race they are, but accept them as an individual, unbiased, and treat each of them with dignity and respect. And again, I believe respect is first offered and then received. Thank you.
Socrates said it best, and that was 2,400 years ago, that a judge should hear courteously, answer wisely, consider soberly, and judge impartially. And those are the characteristics that I will bring to the bench. I've been proud in my career to not be demeaning, to listen to people, to be patient, and to think before I speak. And when I make a decision, it's thought out, it's researched, and to my best of my ability, it's right. And fundamentally is to treat all people with dignity and respect and equality. Doesn't matter race, gender, religion, disability, or name. Everybody who comes before me will get those four things that I just stated.
This question is for Mr. Seaton. Mr. Seaton, on December 5, 2011, you held a trial in Yuba County. You stated to the judge that you had back pains and you were taking medication. During the trial, you would joke about taking the medication to the jury, shaking your bottle and saying, "I defend people who take this." February 14th, same case, same judge. You adamantly denied taking medication during the trial. Which day did you lie to the judge?
Neither. I didn't bring the transcript with me tonight.
Wished you would have.
The circumstances is Diana and Jack Perdue wanted me. We were best friends for 10 years. They came to me because their son was being charged with having sex with his 14-year-old daughter and raping her. giving her marijuana and beer, alcohol. Very reluctantly, because the first thing they teach you in law school is don't represent friends or family. Reluctantly, I agreed. The morning of December 3rd, I was awakened at 4 in the morning with a sciatic nerve problem that I'd never experienced in my life. I brought that to the judge's attention the next Monday afternoon, the day before the trial started. The judge said, do you want to continue this trial? I said, no, I can do it, Judge. I did go to the doctor. I have medication, but I will not take it during court. And I didn't.
No debate.
On February, ultimately her son was convicted of all 13 counts. All right? Now it's my fault. Now I'm not going to discuss any issues in that case, except the fact that her son wanted another attorney. Told the probation officer he wants another attorney. So I filed a motion to withdraw as attorney of record based on a conflict of interest. That motion was heard on February 14th. Judge O'Connor, Department 5, Yuba County Superior Court. And I don't have the transcript, but if you want a copy of it, come talk to me. I can read it to you. I can't give you a copy. At any rate, I'll let you read it. And she stated very specifically that she did not find any fault in my vigorous defense of her son. She stated that on the record. So, with that, ladies and gentlemen, I refuse to discuss this case any further because it's an ongoing case.
When I was 17 years old, I swore to uphold and defend the Constitution of the United States of America. I served 6 years. At the end of my 6 years, my giving myself to the Constitution and the pledge thereof didn't stop. I heard a few weeks ago at a Tea Party meeting where both of you were present, I heard Mr. Hermanson, and I'm not singling anybody out. What I want to hear is from both. I want to hear this answer from both of you individuals. I heard Mr. Hermanson say that because of certain things taking place in the state, that we would need to get creative from the bench. What I heard, and this is just myself, is that a judge would have to compensate for the state's inadequacies.
Let's get your question.
What I would like to know is what you feel about the Constitution of the United States and how you're going to uphold that, not as some of our judges have recently, thinking that the document is outdated, but something that was given to our country as the document that America is all about, the dream, the inspiration. I want to know from both of you what you're going to do to uphold that.
Okay.
The forum last week was the question was asked, our view of the law and whether it changes with society or whether it stayed the same. And there was a distinct difference between mine and my opponent's answer. Mr. Seaton answered that he thought the law changed dependent upon the needs and will and the fluctuations in society. I was very succinct. In fact, I follow Justice Berger's concept, and I always have. The judges rule on the basis of law, not public opinion. And they should be totally indifferent to the pressures of the times. That's always been my answer. So at the Tea Party, I would never say that the law fluctuates. But I will tell you that as it relates to 109, the judiciary is going to have to be a little more creative, not in the application of the law, but in the application of what type of sentences occur. I have never deviated from that concept that I just stated to you.
What I said last week ago, Monday, up country, was I believe in the spirit of the law. There are times when the black letter law should be applied, but there's also times and circumstances and situations that the spirit of the law should be applied. Now, the law does not change unless the appellate courts change the interpretation of the law, or the legislature change the law, or our federal is Congress. So, how would I implement the Constitution? Well, I believe in the Constitution. I've defended it since 1973. Before I would make a decision, each issue needs to be researched. And when I say research, not just what the black letter law is, but how that law has been interpreted by the appellate courts to include the Supreme Court of California and the Supreme Court of the United States. And whatever precedents that court, let's say the Supreme Court of California or the U.S., however that court has interpreted that law and how it should be applied to a given circumstance and situation is what a trial judge is bound to do. We can't just arbitrarily say, oh, well, I think it should be applied this way. No, we have to follow appellate procedure. It's called stare decisis, okay? We have to comply with the appellate courts. That's our system. That's why we have a U.S. Supreme Court. I think that answered your question.
In my line of sight, I didn't know if there was any questions over here. So, yes, sir.
Yeah, I've got a question for Mr. Seaton. I'm on the document in my hand that was filed, endorsed, and et cetera in the county of Sacramento, where it lists several of your, and this goes to the fiscal questions that they were asking earlier as far as being a judge. There's some fiscal changes that are going to have to be made, and this goes to how you handle money, basically. And I'm looking at this document, and it's got $33,005 plus in delinquent monies owed to, including the state and federal tax board, $30,000 a year in spousal support that you don't seem to be paying. You list $70,000 in legal fees you charged off in credit cards that are not included
Okay,
here.
let's get a question going.
If you can't handle your own personal finances, how in the world are you going to be handling finances as a judge and dealing with that kind of stuff?
Okay.
Good evening, Mr. Oliver. How are you doing this evening?
I have other questions too if they will.
Let me answer the question.
Let's face the reality. I was watching the debates that the Republican nominees or Republican candidates debate months ago, and one of the moderators addressed Newt Gingrich about some issue regarding his marriage.
Let him answer the
And
question.
Newt Gingrich said, "Sir, you are a despicable individual." Well, you know something, Mr. Oliver? I am not going to call you a despicable individual. What I'm going to tell you is that I'm not going to discuss my personal case in front of you or anyone else in this courtroom unless I feel the need to do so.
Amen.
So my name is Louise Silver. I recently, over the past year, I've had the experience of being in a family law court with a friend of mine. At one point, just to cut to the chase, the attorney who was appointed to represent the children motioned to the visiting judge, to put down, to quash, basically, and I don't know it's been a few years, so I'm not sure exactly what the correct legal term is, to make it so that any evidence of child molest would be eliminated from that court case. That judge, that visiting judge.
Okay, you have to ask a question.
Well, I will.
Okay,
Oh,
get to your
trust me,
question.
I will. That visiting judge went along with that. He totally did. At that point, that became stare decisis. And at future case, at future
Ma'am, you
times
have to
down
ask
the
the
road.
question. We're
Okay.
over a minute.
How would you decide a case like that where an appointed attorney comes to you, appointed to represent the children's interests, comes to you and says, "Judge, I would like to motion," that was the word, motion, pardon me.
Okay, we've got it. Let's
To
let
suppress the evidence.
both candidates
Thank
answer
you.
that question.
Ma'am, you obviously appear to be very upset, and I understand that. I'm trying to understand that. Having not been in the courtroom, not knowing who the visiting judge was, not knowing the parties, not knowing the facts, not knowing the issues. It would be improper for me to tell you how I would have ruled. Judges have to be fair and impartial. The judicial candidates are held to the same canons of ethics that judges are. And a judge cannot prejudge. So I'm not trying to avoid your question, but I cannot give you an answer because there are too many issues and too many facts out there that I'm not even familiar with. I'm sorry.
The role of a good attorney would be to explain to you what was going on in terms that you would be able to understand, and at least you don't have to accept the rulings because sometimes it seems contrary to logic and it upsets you. But at least that you would have an understanding of what had occurred. I can't go back in time and say how I would rule on something unless I heard the whole thing. But I think the failure of the system at that point was either the attorney not explaining it clear enough, the judge not explaining his ruling clear enough, and that's what should have happened in that courtroom, so you had a clear understanding of everything that had occurred and the basis that the judge is making his ruling. The most important thing a judge can do when he makes a ruling is set out a clear basis, so that if you disagree with that, you can take it to the next step.
Yes, ma'am.
Hi, Mr. Seaton.
Hello, Dusty.
In December of last year, you told a judge in Yuba County that you had seen a doctor and were on medication for pain.
Is this a repeat of the first question?
No, it's not. March 15th of this year, you filed a sworn declaration with the Sacramento stating that your financial situation. No.
Ask the question, ma'am.
Okay. It's all about medical problems. Is your ongoing medical problems going to affect you as being a judge?
No. Who doesn't have a backache? Anyone here never had a backache? Never had an upset stomach? Never sprained or pulled a muscle?
You are human.
Never broken? I mean, maybe everyone's not broken a bone, but comes with old age. Sorry, I'm not 25 years old and I don't profess to be. But I'll tell you what, I'll outwork any attorney in this county, and I have for a number of years, and I do not mean any disrespect to any attorneys. None. My adversary right here. If any of you know where my office is at 435 Court Street, for the last 18 years, I have many times worked 7 days a week into the late hours of the evening, and to include weekends, holidays. Do I sound like somebody who's on drugs right now?
No.
Do I sound like somebody who's walking? No. Ladies and gentlemen, I went through a 2-week jury trial at my own expense, and I was in severe pain, but I continued, and it did not affect my cognitive ability or I call it intestinal fortitude, and I'm not trying to be disrespectful to anybody. But it comes from within, and that is Jeff Seaton. When I have a mission, when I have a job, it comes from within. I don't know what time it is. I don't know what day it is. My job, and I learned this in the military. Duty, honor, country.
Amen.
30 seconds.
And mission is always accomplished. There's no such thing as can't. There's no such thing as no. You do your best with what you have to work with, and you give it your hardest. And no, as I stand right now before you, my medical condition is not going to impair my ability to be an attorney, or to be a judge, or to be anything else that I haven't been in my life. Thank you.
My name is Michelle Hamilton, and I'm a supporter of Jeff Seaton, and apparently I found myself sitting among a lot of Hermanson supporters over here, which is fine. I did have a prepared question just for clarification of both candidates, but I would rather ask Mr. Seaton a question based on a conversation I overheard over here. And I think it's severe enough that I just want to hear clarification from you. There's a gentleman over here that you had identified as Mr. Oliver earlier. I didn't know who this person was.
That's me.
But he was telling these other gentlemen sitting here that you had threatened him verbally and had told him that he needs to watch his back.
Okay, get your question.
In turn, he sleeps with a .38 revolver. So my question, Mr. Seaton, is this true?
I sleep with a 357. There you go. The answer is no. I've never threatened Mr. Oliver. After the meeting that we had, the Candidates Forum up country a week ago Monday, Mr. Oliver followed me, tried to bait me and entice me, asked me why I didn't join in the blogs on the internet. And here's what my response was. I don't blog. I don't blog on any blog. And I'm not going to blog with you. And he said, well, why? Why don't you come out and defend yourself? And my specific response was, because I'm not going to lower myself to your level. And I walked away.
You mentioned mediation in the civil context. I worked in Frontline Calaveras on a couple of areas, family law and CPS. How would you use mediation to speed things up in those areas in this county?
Thank you. Both questions, both candidates?
Please.
Start with Mr. Herman.
I think we need to have a good mediation process. I think it would be nice to contract with other counties' attorneys or get them to come on board and do peer mediation. I think peer mediation can go across not only from civil but into family law. I think that it can work in both contexts. But as I said earlier, I think that in order for that to be effective, your panel of mediators have to be good. They need to be qualified, they need to be good at what they do. So they have to have a certain level of experience, a certain ability to communicate in order to get the parties to come to an agreement. But I think the first thing we would have to do is have a very well thought out mediation process and implement it. And stick to it. You know, anytime you develop a process, it takes a while. There's going to be failures along the way, but you adapt and you make it streamlined and you make it effective. And we need to do that in both the civil arena and the family law arena.
Well, as I stated earlier, I went through the same mediation program as did a few other people in here, attorneys and Judge Harlan. Now, for mediation to be effective, you have to have qualified, trained mediators. Mr. Keene, correct me if I'm wrong, you're appointed by the court to represent the children's interests in family law and dependency cases?
Over there.
Over there, Calaveras, yes. As a judge, I would focus, or I would pay very strict attention to the attorney that's appointed to represent the minor. And the reason there's an attorney appointed to represent the minor normally is because there's a tug and pull between mom and dad or other family members. So having the child having his or her own attorney represent his or her interests is very important. I'm not saying I would personally mediate. There may be times when I may enter that area, but for the most part, I think a judge has more important things to do with the cluttered calendars. But I would certainly encourage both parties to listen to you and for the mediator to listen to you. And I don't mean just you as an individual, but the child's attorney. But again, that mediator has got to be trained, has to be qualified, and has to have basically all parties' interests at heart and resolve this. And this is the state legislature. The state legislature is most concerned about the best interest of the child, and that's why an attorney is appointed to represent them.
My question is for both of you gentlemen. Both of you have spoke about supporting our veterans, especially those returning. I'm a Vietnam combat veteran. My question to you, both gentlemen, is if you have a young person standing before you, and let's say he's committed a serious crime, murder, whatever that may be, following the law, I only served one tour. and that I was asked to serve one tour. We have our young people out there that are serving more than one tour of duty in combat. Not because they want to, but because they're called upon to go back.
Get your question.
The question is, if you have this young person standing before you, how are you going to help that veteran following the rule and following the laws?
I'm not faulting you for your question or the way it was worded, but the law is much more complicated than that, because a person has a right to many different proceedings in various types of cases. And the ultimate proceeding, well, prior to sentencing, the ultimate proceeding would be the proceeding to determine innocence or guilt. And that's determined by a jury in a trial. It depends on the degree, the severity of the offenses with which he or she would be charged. If it's drugs, it's a lot different than someone committing murder. And I can't tell you, again, like I've said before, I can't tell you how I would rule, because there are too many variables and facts and issues. But one thing that I would do is try to get to the truth of the individual, what he did, why he did it, was he sane? Does he understand the nature of the proceedings? A lot of different issues here, and I just can't answer it with such a wide spectrum.
You answered what I wanted to do.
With a wide brush. I'm sorry.
The more serious the crime, the less flexibility the criminal justice system has in regards to what happens to that individual. And AB 109 distinguishes between serious crimes and less serious crimes. In serious crimes, we would not have all of the options, perhaps, in a case like murder. But we would have those options in other cases. And as I spoke of a VA court earlier, the important components of a VA court are an advocate from either the American Legion or the VA that helps that veteran go through that process, explaining it to them, and also advocating for what programs are out there. So that if an individual is sentenced, they get sentenced to something that is going to benefit them. So if it's a residential treatment, it's a residential treatment put on by the VA so that they can address those specific needs of the PTSD, etc. That's how we would treat that individual different than a person who is a substance abuser. Recognizing the cause and then treating it.
Four questions over here, and we'll get to each of them. This lady here first.
For Mr. Seaton. With your display a moment ago with the lady behind me here, it's very important for a judge to have the proper temperament. Do you feel you have the proper temperament to be a judge?
Yes, I do. I'm human. Someone tells lies about me, accuses me of something that is totally falsehood. My initial knee-jerk reaction, yes, is to defend myself with facts, documents, etc. But I will say this. No judge is perfect. No person is perfect. And if I, as a judge, would have difficulty with any party, any witnesses from my past, from whatever happens outside the courtroom, I would be obligated. It's my duty to disqualify myself from that case. Even when there's just a presumption of bias. No real bias, but just the appearance of an impropriety or the appearance of bias. So yes, I would definitely disqualify myself, and that's pursuant to 170.1 of the Code of Civil Procedure.
I believe you've had a question asked, so I'm going to get everybody else before I get seconds. Sir, you've been waiting.
Thank you. I'm going to try and form this in a statement rather than a question. So,
Is it directed to both candidates?
Well, at the moment, both candidates are very much aware of the California
Ask the question.
rules
Go ahead.
of professional conduct. A nod would be acceptable. Mr. Seaton, you're aware
Is
of
that a
those?
question?
You're aware of the rules of professional conduct, California
Under the
rules?
Business and Professions Code.
Yes. And they're taken very seriously by the State Bar Association. I imagine that the judges, they'd be even more rules to abide by. Are you familiar with rule number 3-100, the confidential information between clients and attorneys? And I'm sure that you know of it. If not, I can cite the entire
So you're making
deal.
a statement, I need a question.
All right, how did your current girlfriend, Darlene Hum, get a hold of privileged information from your office and post it on a public forum, things that were known only to you and your client?
Okay, your time is up. Let me answer the question.
First of all, I don't know what you're talking about.
Oh,
excuse me.
yes.
No, let me go back. Yes, I'm very familiar with the confidentiality. Okay? I don't know what the rest of that you're talking about, Jack.
The public forum that you mentioned 5 minutes
You got to
ago.
let him answer the question.
You haven't
We can't get
spec-
into that. You're out of order.
The only thing that I hear you doing is attacking me, and you're trying to attack Darlene Hum. You haven't told me what information was confidential, what information was leaked, who it was said to, the circumstances,
I can tell you.
etc.
No.
So,
Out of order.
so
Let me
Jack,
answer the question.
I can't. There's no confidentialities that have been leaked out of my office regarding your son's or your nephew's case. Excuse me, your stepson and nephew. It's one and the same. Has not been leaked out of my office to anybody. Thank you.
Really?
All right. Next question.
Wow.
Next question. Yes, ma'am.
This question is directed to Mr. Hermanson, but Mr. Seaton, if you would also like to answer, I don't want to preclude you from that possibility. Mr. Hermanson, could you please explain how you have supported and defended our United States and state constitution throughout your legal career?
I hope there's no misnomer. Mr. Seaton said earlier that I believe he took an oath when he got licensed. Every attorney that gets licensed swears an oath to the Constitution of the state and the U.S. It also is imperative that the attorney understand the hierarchy of laws. The U.S. Supreme Court, the U.S. Constitution is the ultimate law of the land. It is. And everything else comes under that. So you have to understand your conflict of laws principles as it relates to that. When I became a deputy district attorney, again, I had to take an oath to defend the state and federal constitutions. I have done that throughout my 20-year career, and I will continue to do that.
I took the oath to support and defend the Constitution of California, United States, as an attorney, and I've done that. Well, how have I defended it? I defend a person's right against Fourth Amendment against unreasonable searches and seizures. I defend a person's right against self-incrimination. I defend a person's right under the Sixth Amendment, right to a speedy trial, right to cross-examine the witnesses and evidence against him or her. That's what a defense attorney does. That's why we, in my position as a defense attorney, I have to ensure that my client's rights, the rights, are not infringed upon and violated. And a good example of that in this IL is People versus Ramey. Mr. Ramey was incarcerated in El Dorado County, and he went to state prison. But before he went to state prison, he was charged with having committed some crimes here. The DA's office in Amador County failed to prosecute Mr. Ramey in a timely fashion. Some 6 years later, while he's still in prison, Mr. Ramey's brought back to Amador County to face these charges that happened 7 years ago. Well, guess what, ladies and gentlemen? That's a violation of the Sixth Amendment right to due process. I filed a motion to dismiss that case based on the Constitution, California Constitution and the U.S. Constitution. Mr. Hermanson was the opposing counsel. He didn't even file a response to my motion and my points and authorities because he conceded that Mr. Ramey's rights had been violated and the case was dismissed. Thank you.
gets the roll.
This is not my question, but I would actually like to hear Mr. Hermanson's response to that. But my question is this, and I'll get to it quick as I can. There's a lot of blog stuff, rumors going around. I went down to Sacramento on Monday. I spent 5 hours at the William Ridgway Family Law Center. It's a nightmare. And I read what appears to me to be a closed case now. It looks like the final judgment was entered on March 30th in Mr. Seaton's most recent dissolution. What I'm concerned about is Mr. Seaton's own income and expense declaration that he wrote and signed under penalty of perjury lists, and these are his numbers, almost $700,000 in debt, $55,000 of which is credit card debt.
What relevancy does
Okay,
this have?
you
What
need to get a
question do
question.
you have, sir?
Let's get a question.
What's the relevance?
Yes.
Let's ask the question.
$700,000 in debt. I'll be within my minute, believe me.
No, you're over the minute. Ask the question. If Mr. Seaton is willing to respond, that's fine.
Well, I have...
You've lost your time. Go ahead, let him respond.
I had a home built in 2004, right up on Climax and Tapes, on 6 acres. That home was appraised in 2004 at over $1 million. In 2008, my ex-wife and I obtained an equity line of credit on that same piece of property. Bank of America appraised it at over $1 million. Well, guess what? Who isn't aware of what happened to the economy and real estate prices? Am I in debt? Yes, I'm in debt. Who isn't? Is there anybody in here who's not good for you, sir? I mean, good for you. Do I pay spousal support? Yes, I do. Hey, I represent husbands, wives, and family law. For the most part, somebody's going to pay spousal support if the marriage is over 5 years old. Okay? For the most part. Okay? So, all of these questions, Mr. Ebhart, are just trying to attack my credibility, my character. But you can rest assured that those credit card debts, and this is the bad part about lawyers, went to a certified family law specialist in Sacramento to represent me. Because you know how expensive lawyers are. You're a lawyer too.
Earlier, Mr. Seaton,
Speak up.
earlier, Mr. Seaton stated that he applies laws based on, among other factors, social influences following the spirit of the law rather than the letter of the law as it is written. Then if you are applying the law based on partially on social factors, how can you claim to continue to be impartial?
Okay. That question is for only Mr. Seaton, is that correct?
I don't know what he's talking about. But social factors, I don't know what social factors you're referring to, sir. I can't really formulate a coherent response because I think that's an incoherent question. Thank you.
It's your words.
But keep on my response.
All right. We've got about 10 minutes left before we move to the final phase of questioning. Yes, sir.
Question for both candidates. Earlier, you spoke about the caseload of the judges, and one of the things that really stood out for me was 6,000 cases of traffic cases. So in other countries, there are magistrates courts that handle things like that. Do you have a plan to alleviate the Superior Court judge from having to deal with cases that could be dealt with by magistrates or some people like that? Do you have a plan to alleviate the, just say the traffic cases? It seems that it's 80% of the caseload is traffic. Do you have any plans for that? Thank you.
There are, in different counties, different uses for commissioners. We have a commissioner in this county who is also the research attorney. There are certain counties that use a commissioner and extend his role into traffic court and into other courts such as probate and family law? And that's actually a great question. I just became aware of those statistics when I was looking at the impact on the court last week. And the first thing we have to do is look at how to streamline and make it more efficient. And I think the first thing I would look at is, can any of those obligations on the traffic court go to a commissioner? And if so, can this commissioner handle that? And if not, can we fit those cases in any openings? Remember, we have 100 days where we didn't do something. If we can fit those cases in that span of time so that we alleviate some of the problems and impact on the court.
How I would handle that in two ways, preferably with a judge pro tem. Now, back in the mid-90s, I performed duties as a judge pro tem in traffic court right here in Amador County because Judge Howard's calendar was too busy, just not enough time. So I don't know if any other attorneys were asked to perform or to hear these cases as a judge pro tem, but I did. And I did a good job. In fact, I'll tell you what, more often than not, rather than make a decision, I somewhat acted as a mediator because the person that received the ticket might say, well, okay, I didn't do this, but okay, yeah, I did this over here. I did cross across the left to center on that turn, or something like that. I'm just as hypothetical. So I think judge pro tems are a vital asset to Amador County. The Amador County Bar Association has some very qualified attorneys and very experienced attorneys, and I would tap that source. My second alternative would be the commissioners. Commissioners right now are primarily just used here for family law, child support hearings. And we eventually share. Commissioner Garrett performs duties in Calaveras County as well as here, hearing child support issues. So I would have to explore the possibility and likelihood of having a commissioner perform those duties. But yes, those would be my two alternatives.
We've got time for probably only one more, unless it's just to one candidate. So, Floyd, let's go to you.
I heard both
I'll go
candidates.
to you next, man.
I heard both candidates say that they believed in the Veterans Court. I don't know how much research you've done in that, but there's a lot of veterans in this room, Legion, non-Legion, and so forth, that believe in our Constitution of the United States of America, and hopefully everybody enters it. But my question to both of you, because I heard someone say something about your Facebook, Mr. Hermanson, that you felt that the prosecuting attorney is greater than the defense attorney. Are we to assume we're going to get away from you're innocent until you're proven guilty, or are you going to be guilty until you're proven innocent? So which way do we go?
Everybody hear the question in the back? Okay.
I'll read you the exact statement from the U.S. Supreme Court. A prosecutor is held to a standard higher than that imposed on other attorneys because of the unique function he or she performs in representing the interests and in exercising the sovereign power of the state. It goes on to say, whose interest therefore in a criminal prosecution is not that it shall win a case, but that justice shall be done. Don't misinterpret what I said. What I said is that the prosecutor is held to a higher standard. They have a separate duty, a separate obligation under the law. Doesn't make it better, doesn't make it worse. But understanding the law and understanding what your role is within that is imperative. A judge better understand that, and the attorneys involved in that case better understand what their role is.
Mr. Hermanson and I disagree. I think that was dicta out of the Supreme Court case. At any rate, every attorney has the same high standard. Now, the judge has the same high standard. Support the Constitution, seek the truth, do not perpetrate any false evidence or frauds upon the court knowingly. What Mr. Hermanson read to you, you listened, do not misuse, and I'm paraphrasing, not to misuse or abuse powers of sovereignty. See, prosecutors, district attorneys, and the Attorney General's office in California, they have more power than I do. Mr. Hermanson has more power than I do. He works for the executive branch. And I think what that phrase, the dicta that he's reading really means is, you're held to a higher standard. Don't abuse your authority. Do not abuse your authority. But I don't have that authority. If I had the authority, it would be the same. Mr. Seaton, do not abuse that authority. But we are all held to the same highest standard, in my opinion.
I have a two-part question.
We've only got time for one more. One question.
Our current Superior Court judge has served our county for 20 years, and I was wondering where you see yourself in 20 years or even 6 years, and can you tell me about
Can you
your...
speak up, please?
Sorry. Okay. I'm wondering where you find yourself serving in 6 years or even 20 years, and also I think it's important that our judge has integrity, good character, good temperament, family values, commitment.
Okay, so you're
And
asking
so I
a
would
question
like-
of both candidates
Yeah, I would
to
like
talk
to
about
hear
where
them
they
talk
want
about
to be
their
in 6 years or
integrity,
20 years.
family values, commitment, and where they
Does
see
everybody understand the
themselves
question?
in 6 years, 20 years.
Okay, go ahead. Mr. Herman, you want to start?
We are truly in unusual times right now in our county. The situation is changing with AB 109, with the impact on the courts and the impact on our counties. I don't think it is going to be resolved in the next year, 2 years, or 5 years. And whether you're a judge or whether you're the public, my best advice to you is never become complacent. Never become complacent. Because I think this is going to be a battle that goes on 10, 15, 20, 30 years. It's going to be a long-term battle. I don't think that our economy is going to flip suddenly and we're going to have all these funds to address these issues. So we're going to have some energy. And I do believe it's going to take a span of time. I'm 47. Some might consider that young, some might consider that old, depending for my son or someone else. I think that developing the programs and implementing them is going to be a long process. And I'm willing and capable and have the desire to serve more than one term, to implement those programs, see them through, and get to the end.
Well, to paraphrase Ronald Reagan, I refuse to make age an issue in this campaign, because to do so would be to take advantage of my opponent's youth and inexperience. Where do I see myself? I see myself moving forward. Let's see. Governor Brown was what, 72 when he was elected governor? Right? Okay. I don't even know how old Ronald Reagan was. I know John F. Kennedy was the youngest president to be elected. So I know where you're going with this question, ma'am. But the fact is, as long as I'm healthy, as long as I have my mind, I am working. I have worked from day one as a teenager. I continue to do so. I mean, Judge Howard's in his 70s. He comes in and presides over jury trials. So, besides that, we also have age discrimination laws that I think should be addressed.
The question wasn't answered.
Well, we're done with the question and answer from the public, ma'am. So
It was about family values.
You'll have to yield. You have to yield now. I have to get on with the program.